Fundamental rights and climate protection in the Brazilian Constitution of 1988 will be the subject of this video paper that I'm glad to present to everyone through this short lesson. My name is Ingo Wolfgang Sarlet. I'm full professor for constitutional law at the Pontifícia Catholic University, Rio Grande do Sul, Porto Alegre, Brazil, former judge at the State Appeal Court, and actually lawyer and legal consultant. The climate issue is the issue of our time. It is the question that destiny is directing at us, and the answers that we are able to formulate will decide what future humankind will have, or whether there will be any future at all. There is no other agenda, there is no other problem, there is no other question. Climate emergency is the anteroom of all other emergencies. This is a statement from Judge Luiz Edson Fachin of our Brazilian Federal Supreme Court in a recent decision undertaken, enacted by the court. The present climate crisis resulting from global warming and climate change constitutes a great challenge, not only, but also and especially for the theory and practice of constitutional law and fundamental rights. There is even reference to a novel subdiscipline, the so-called climate constitutional law. The seriousness of the climate issue and its consequences is notoriously of such a magnitude that some countries have even declared a climate emergency state, as it was done, by instance, by the European Union through the European Parliament in 2019. The recognition of a state of climate emergency has found a broad support in the scientific community, as shown, for instance, by reports of the United Nations Intergovernmental Panel on Climate Change, particularly the 6th report released between 2021 and 2022. This scenario of already caused harms and serious risks to human life and the biotic and abiotic environment, as well as to human dignity and human and fundamental rights, has given rise to an important discussion in legal scholarship around the recognition of a fundamental right and human right to a clean, healthy, and safe climate. Having this in mind, our goal is to make some remarks on the recognition of a human and fundamental right to a clean and safe climate in light of the Brazilian constitutional and legal order, but always looking at international level and even some brief references to other legal systems. It should be underlined that in spite of the prevalently constitutional approach in the Brazilian case, the topic is part of a context necessarily marked by an intense dialogue between legal systems and a multi-level perspective characterizing the interaction between international law at the worldwide and regional level and the state's domestic law. Perhaps we might speak of a climate law without borders or frontiers, as suggested by Vasco Pereira da Silva in the field of constitutional law. This transnational multi-level constitutional approach regarding the problem of the protection and promotion of a balanced and healthy environment, and particularly of safe climate conditions, becomes especially relevant given the fact that the problem has a global dimension, and that regardless of the individual greater or smaller participation of each state by the emission of greenhouse gases, each one must contribute to overcome the planetary climate crisis. That's why the concept of transnational system of shared responsibility should be taken more seriously. Coming back to the Brazilian case, one could start mentioning that according to the set of fundamental principles which guides Brazil international relations, the framers of the Brazilian Constitution of 1988 conceived the Brazilian state as an open and cooperative one. Also, the principle of the prevalence of human rights has been gaining importance in this context, also and mainly in the domain of environmental protection and climate issues. In which concerns the constitutional environment framework, the first aspect to mention is that in Article 225, The federal constitution recognized a fundamental right to an ecologically balanced environment, right that was not included in the constitutional fundamental rights catalog contained in the second part of the constitutional text, following the fundamental principles. Despite this circumstance, the Brazilian Federal Supreme Court, with strong support from the legal literature, decided in the 1990s that considering the umbilicate relation between the protection of a healthy and unbalanced environment with the right to life, the human dignity, and the effectiveness of other fundamental rights, the right to environment is indeed a fundamental one and deserves the same constitutional guarantees. Only for now, taking into account the environment in the constitutional text, the climate issue is still waiting for a more substantial consideration. But this is only a question of time. This first step was done through Constitutional Amendment 123, 2022. A new item 8 was included in paragraph 1 of Article 225 of the Federal Constitution that textually regulates precisely the Brazilian state's duties of climate protection in the sense of promoting the decarbonization of the economy and neutralization of the climate concerning the greenhouse gas emissions resulting from the burning of fossil fuels by maintaining, I'm quoting here, a favored fiscal regime for biofuels designed for final consumption in the form of supplementary law in order to guarantee them a lower taxation than the one payable on fossil fuels, so as to ensure them a competitive difference in relation to the latter. Besides this, at the moment, 2 constitutional amendment proposals are being discussed in National Congress. Proposal 233 from 2019 and Proposal 37 from 2021, and both aim to include the climate agenda in the constitutional text. The present version of Proposal 37 aims to include the right to an ecological balanced environment and to a safe climate in the first article of the Fundamental Rights Catalog, along with the rights to life, liberty, equality, security, and property. According to the other amendment proposal, the maintenance of climate security and the guarantee of actions addressed to the mitigation and adaptation to climate changes should be included in the guiding principles and objectives of the constitutional economical order. A similar formulation, according to the same proposal, should be included in Article 225, which recognizes and regulates the right to a healthy and balanced environment, creating a specific state duty to adopt actions of mitigation of climate change and adaptation to its adverse consequences. This request has also gained increasing significance at international level, as in this context too, there are already appeals for the recognition of a human right to a clean, healthy, and safe climate, as shown ahead in more detail. Also from this perspective, the ecological rule of law must henceforth necessarily incorporate also climate dimension. But before advancing this aspect, it's of utmost importance to underline that the climate has gained the position of a common good and interest with constitutional status, and of course, also in the perspective of international law. Climate as a legal interest refers primarily to the global or planetary atmosphere, although regardless of the absence of territorial borders, it also has a regional, national, and local dimension, not only considering the factual peculiarities, but also in legal terms, because the legal regulation of all these spheres continues to exist and is to be absolutely relevant. The International Court of Justice, in the advisory opinion on the threat on legality of the use of nuclear weapons, 1996, at the time recognized that environmental protection is part of the corpus of international law, through the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control. The court also recognized that, quoting here as well, the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn. Climate as a legal interest can be equated in certain aspects with the category of global commons, such as seas and oceans, particularly the deep sea, the Antarctic, aquifers, such as in Brazil, the Guarani aquifers in South America, the Guarani aquifer, no? The Amazon forest, for instance, as the largest rainforest in the world, but mainly because of its crucial importance for the integrity of the ecological and climate system at the planetary level, would also be considered a global common interest, notwithstanding the discussion about the sovereignty of the involved countries, such as Brazil, which has about 60% of the rainforest territory. In this sense, the integrity of the climate system can be identified as a common concern of humankind, a phrase expressly used in the preamble of the Paris Agreement 2015, quoting here, acknowledging that climate change is a common concern of humankind, parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights. Just to mention a recent example coming from another country, we highlight the provision contained in Article 3b of the Framework Climate Law from 2021 from Portugal about the goal of its climate policy, namely to, quoting here, guarantee climate justice, ensuring the protection of communities most vulnerable to the climate crisis, respect for human rights, equality, and collective rights over the commons. The preamble of the Paris Agreement illustrates the acknowledgement of the relation between climate change and fundamental rights and human rights, of course, from an international point of view, particularly due to the interdependence and indivisibility that increasingly characterizes the legal regime of fundamental rights. Environmental protection and the guarantee of a safe and healthy climate are in any case transversal and omnipresent issues as well known, but both for the current and future generation. But it is above all the life, dignity, and fundamental rights of younger and future generations that are more threatened by climate change. For instance, if we see the increase of 1.5 degree Celsius in the global temperature, counting from the pre-industrial period onwards, as pointed out by the IPCC reports. A more recent case deserves mention as to illustrate the importance of the debate on climate justice between the various human generations in the constitutional sphere. Here we mention the Neubauer et al. Versus Germany case, judged by the German Federal Constitutional Court in the first half of 2021. The constitutional complaints that lead to the court decisions were submitted by a group of 9 persons, most of them young, including the German activist Luisa Neubauer of the Fridays for Future student movement, supported by several environmental entities. Among the plaintiffs, there were even residents of other countries, such as Nepal and Bangladesh. The latter is one of the countries most vulnerable to the rise of the sea level due to climate change. Among the various arguments presented for the court, there are alleged violations of the fundamental right to a future consistent with human dignity, menschenwürdige Zukunft, and the fundamental right to an ecological minimum standard of living, ökologisches Existenzminimum. At the occasion, the court acknowledged the violation of the state duties of environment and climate protection in the domain of the Federal Climate Protection Act of 2019, which, according to the court, spread out in a disproportional manner between the present generation and the younger and future ones, the burden derived from restriction on fundamental rights, particularly the right to freedom, resulting from the regulation of the emissions of greenhouse gases by providing for reduction targets until 2020 only. By acknowledging the unconstitutional provisions of the German climate legislation, the court stated that the legislator violated its duty to ensure that, quoting here, the reduction of CO2 emissions to the point of climate neutrality that is constitutionally necessary under Article 20A from the basic German law be distributed over time in a forward-looking manner that respects fundamental rights. It is the right to the future, and particularly the exercise of fundamental rights in the future, that is at stake. It registers in the German Federal Constitutional Court ruling. The decision of the German Constitutional Court is just one, but very important example of the more recent developments concerning the constitutional protection, environment, and the safe climate, and as well of the growing climate litigation. More recently, at international level, the UN General Assembly, through its resolution A76L75, in its historic acknowledgement of the human right to clean, health, and sustainable environment, stressed precisely that the threat that ecological and particularly climate crisis represents to the future enjoyment of human rights by coming generations, by pointing out that, quoting, environmental degradation, climate change, biodiversity loss, desertification, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to effectively enjoy all human rights. The acknowledgement of a right to clean air and the correlated state climate-related obligations are expressly dealt with in the report on the issue of human rights obligations relating to enjoyment of a safe, clean, healthy, and sustainable environment, AHRC 40-55, by the Special Rapporteur on Human Rights and Environment of the UN High Commissioner for Human Rights, David Boyd, published in the beginning of 2019. According to the document, poor air quality has implications for a wide range of human rights, including the rights to life, health, water, food, housing, and an adequate standard of living. Air pollution also clearly violates the right to a healthy and sustainable environment. While the General Assembly has adopted numerous resolutions on the right to clean water, it has never adopted a resolution on the right to clean air. Surely, if there is a human right to clean water, there must be a human right to clean air. Both are essential to life, health, dignity, and well-being. In the same sense, the resolution AHCR 48 of the UN Human Rights Council, adopted shortly before the COP26 in Glasgow, 2021, in a view identical to the one adopted by the above-mentioned UN General Assembly, recognized the right to a safe, clean, healthy, and sustainable environment as an autonomous human right. The text of the resolution states that the Human Rights Council, quoting here, recognized the right to a clean, healthy, and sustainable environment as a human right that is important for the enjoyment of human rights. At the same occasion, through Resolution 48, L27, the Council decided to create a special rapporteur on human rights and climate change, reinforces also that human rights nature inherent in the right to enjoy a clean, healthy, and safe climate. Also, in the Inter-American Regional System of Human Rights Protection, the advisory opinion 23/2017 on environment and human rights of the Inter-American Court of Human Rights also stressed the relationship between human rights and climate change. Quoting part from the court's decision, this court has recognized the existence of an undeniable relationship between protection of the environment, the realization of human rights, in that environmental degradation and the adverse effect of climate change affect the real enjoyment of human rights. Likewise, the Organization of American States General Assembly, OAS as General Assembly, has recognized the close relationship between the protection Regional System of Human Rights Protection, the advisory opinion 23/2017 on environment and human rights of the Inter-American Court of Human Rights also stressed the relationship between human rights and climate change. Likewise, the OAS General Assembly has recognized the close relationship between the protection of the environment and human rights and emphasizes that the adverse effects of climate change have a negative impact on the enjoyment of human rights. Considering the former references, the gradual development of a legal regime, both in the constitutional and international sphere around climate protection, is undoubtable. Having said this, let's return to the Brazilian example. In regard to the constitutional climate protection, legal literature and recently also the Supreme Court recognized the existence of state duties of climate protection binding all state actors. The omission or even the evident lack of efficacy in terms to fulfill the state protection duties is submitted, according to the mainstream in the Brazilian literature and the jurisprudence of the Supreme Court, to judicial control and review. In the analysis of the treatment given by the federal constitution to the state's environmental protection duties, it should be noted that Article 2025 explicitly contains a series of protection measures to be undertaken by public bodies representing normative projections of a general duty of environment protection that the state is charged with. The state in this context is obliged, that's a power and a duty, to establish norms for conducts and activities harmful to the environment protection with a definition of crimes or environmental and climatic administrative infractions, as well as through regulation of the polluter's liability, including atmospheric polluter, emitter of greenhouse gases, deforester, illegal lumbermen, etc., for the damage caused to the environment and climate system. Federal Act number 19605 from 1998 already defined climatic crimes. It should be emphasized that according to the Supreme Court, the list of the state's duties of environmental protection established in Article 2025 is merely illustrative, being open to the recognition of other duties necessary for a comprehensive and holistic protection of the environment, especially due to the permanent emergence of new risks and threats to the environment caused by technological advance and human intervention in the environment, which is now the case of global warming, for example, which imposes new climate protection duties. Among the duties of climate protection resulting from the constitutional regime of ecological protection, one can mention, among others, the prohibition of insufficient protection, the prohibition of worsening or deterioration of the climate conditions, the adoption of climate-friendly solutions. Besides this, in Brazil, literature and jurisprudence, also some important case law from the Supreme Court, has been recognizing a constitutional principle of environmental prohibition of retrogression or retrocession. In this sense, the Federal Supreme Court recognized the unconstitutionality of the state legislation that gave insufficient protection to permanent protection areas in comparison with the national regulation established by the Forest Code from 2012. In that decision, the court expressly recognized the violation of proportionality and reasonableness of the state's legislature action by exposing legal interests of the highest importance, in this case, environmental protection, thus breaching the principle of the prohibition or insufficient or deficient protection. Although environment protection is currently largely present in the agenda of the Federal Supreme Court, climate litigation was, after a series of other lawsuits indirectly related to climate, definitively established only since 2020, with the filing of at least 3 really important suits dealing directly with the climate system protection. In all of them, public hearings of great repercussion were held by the court. Besides the hearings at ADPF number 28, the so-called Climate Fund case, and ADPF number 25, the Amazonia Fund case, held respectively in September and October 2020, we highlight that last and most comprehensive of these actions, number 76, Action Plan for the Prevention and Control of Deforestation in the Legal Amazon case, in which several political parties, along with environmental organizations acting as amici curiae, point to serious and irreparable violations of fundamental precepts resulting from actions and omissions of the Federal Union and federal public agencies that prevent the execution of measures aiming at a significant reduction of surveillance and control of deforestation in the Amazon with their malefic consequences for the climate regime. Considering its relevance also for the consolidation of constitutional multi-level approach, we're now focusing the first final decision in the merit from the Federal Supreme Court in regard to climate changes, precisely the so-called Climate Fund case. Before saying some words about the decision, it's necessary to underline that according to Article 5 paragraph 2 of the Federal Constitution, rights contained in international treaties ratified by the Brazilian state are also part of the constitutional rights catalog. The Supreme Court, however, for a long time didn't recognize a proper legal status for the international human rights treaties, deciding for almost 20 years after the promulgation of the Constitution that those treaties has only the status of federal ordinary legislation. This position changed in 2028, when the majority of the courts started to recognize a supralegal status for international human rights treaties, which means that these treaties should prevail in relation to domestic infraconstitutional law, but are submitted to the scrutiny of the Supreme Court and can be declared eventually unconstitutional, especially since the insertion to the constitutional amendment number 45 from 2004 of a third paragraph in Article 5, international human treaties and conventions on human rights approved by both houses of the National Congress in two different voting sessions by the vote of 3/5 of their respective members shall be equivalent to constitutional amendments, although they do not change the constitutional text itself. Since then, in Brazil, according to the current understanding of the Federal Supreme Court, we have two kinds of international human rights treaties, namely treaties approved with the same procedure of constitutional amendments, and the majority of treaties which have only a supralegal status, at least a supralegal status. Based on this reasoning, it is easy to understand that also international treaties on environment and climate matters, both regarding their material and procedural content, would come to have at least, except for those approved by the procedure of paragraph 3, article 5, a supralegal hierarchical normative nature and prevail over the infraconstitutional legislation. The Federal Supreme Court already had a precedent in this sense since 2017. Judge Rosa Weber, rapporteur in the case, the judgments of the direct unconstitutional action number 4066, in the decision on the constitutionality of the legislation prohibiting asbestos, assigned the status of supralegality to the Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and their disposal from 1989, considering the convention as being equivalent to an international human rights treaty. The recognition of the supralegal status of international treaties on the environment and climate ratified in by Brazil, such as the Framework Convention on Climate Change, 1992, the Framework Convention on Biodiversity, 1992, the Paris Agreement, 2015, situates these international treaties above all Brazilian infraconstitutional legislation, such as the Civil Code, for instance. Only the constitutional norm is hierarchically above them. Another important aspect to be considered is that the so-called Brazilian bloc of constitutionality is not restricted to international human rights treaties, but also include case law, both advisory and contentious, of international human rights courts. To give an example, we mentioned the already presented Advisory Opinion 23, 2007 on environment and human rights, in which concerns climate litigation in the sense of cases related directly to climate issues. The first final judgment from the Federal Supreme Court occurred this year, 2022, the so-called and previously mentioned Climate Fund case. In this case, the court, based on the above-mentioned precedent, recognized interdependence of human rights and stated that, quoting here, treaties on environmental law constitute a species of the genus human rights treaties and enjoy, for this reason, supranational status, supralegal status. Insofar as international treaties, environmental and climatic matters have the same nature as international human rights treaties, they also have a supralegal status and should prevail, as we have seen before. So we can say that this is a tendency being consolidated by our Supreme Court, and which will be very important because all these decisions have a binding and general effect and must be obeyed by all other courts and judges, federal or state ones, in Brazil. However, it must be underlined that the prevalence occurs only in relation to a more protective and stricter normative standard. Otherwise, it's the national infraconstitutional that prevails due to the principles guiding international human rights law and the hermeneutical criterion of the prevalence of the more protective norm, the well-known in dubio pro natura and in dubio pro clima principle is applied here. Coming to an end, it's possible to say that the present crisis and the state of climate emergency resulting from global warming and climate change, as pointed out by the most recent IPCC report, represents an unprecedented challenge, civilizational terms, as well as a challenge for the theory and practice of international human rights law, constitutional law, and the fundamental rights theory and practice. The recognition of a human and fundamental right to a clean, healthy, and safe climate at international level, but especially considering the Brazilian case at constitutional level, has already been implemented and is being developed at legislative and jurisprudential level, besides gaining strong support from legal literature and even literature in general. In accordance with this achievement, the Federal Supreme Court recognized not only the existence of an open catalog of constitutional environmental protection duties, but also specific climate protection duties binding all state actors. The integration in the constitutional environmental and climate protection discourse of international treaties, being or not typical human rights treaties with at least supralegal status, was also an important step forward to strengthen a multi-level protection system. Even knowing that we could only present some remarks on the topic, the current tendency in Brazil, at least take into account the case law of the Federal Supreme Court, is that a positive evolution is going on, and that one can be hopeful in regard to have your right to a future.